The co-defendants were convicted of carjacking and unarmed robbery as a lesser included offense on an indictment charging armed robbery. A third co-defendant indicted for carjacking was tried with them and was acquitted. Vaughan appeals his carjacking and unarmed robbery convictions, claiming that the evidence was insufficient to convict him as a joint venturer. Jackson appeals his conviction of unarmed robbery, claiming that there was insufficient evidence to support the verdict. He also asserts that certain jury instructions were erroneous. We viewed the facts in the light most favorable to the Commonwealth to determine whether any rational trier of fact could have found the essential elements of each crime beyond a reasonable doubt. On April 14, 1998, Tariq Ali was driving his car in Worcester when a red sedan with at least 4 occupants and a juvenile, whom we shall call Robert Smith, drove up behind Ali's car and signaled him by blinking the red sedan's lights and sounding its horn. Ali pulled over and the driver of the red sedan pulled up behind his car. On the pretense of wanting a date, Jacobs approached Ali's car. She asked him to unlock the doors, asked him for his phone number, and returned in the red sedan. During this exchange, Ali unlocked the doors but refused to give Jacobs his number, claiming that he already had a girlfriend. Jackson's argument assumes that the Commonwealth was proceeding on 2 theories of liability and relies on Commonwealth versus Flynn, 420 Massachusetts 810, 652 Northeastern Reports 2nd, 888, 1995. Jackson's reliance upon Flynn is misplaced. In Flynn, the defendant was tried on the theory of individual culpability and on a theory of joint venture. The jury rendered a guilty verdict, but the court reversed and remanded because there was insufficient evidence that the defendant had caused the death individually. The same at 818, 652 Northeastern 2nd, 888. In this case, there was sufficient evidence to establish that Jackson stole the compact discs and that Smith stole the remote. That only the radio remote was specified in the indictment is not relevant. A defendant shall not be acquitted on the ground of variance between the allegations and proof if the essential elements of the crime are correctly stated, unless he is thereby prejudiced. GL, Chapter 277, Section 35. See Commonwealth versus Costello, 392, Massachusetts 393, 467, Northeastern 3rd, 811, 1999. See also Commonwealth versus Gein, 51, Massachusetts Appellate Court, 149, 151, 744, Northeastern 2nd, 665, 2001. Alleged inconsistency in indictment did not afford defendant relief on this theory. We conclude that Jackson's indictment sufficiently apprised him of the nature of the charges against him and permitted him to prepare a defense. Commonwealth versus Gein, 51, Massachusetts Appellate Court at 151, 744, Northeastern 3rd, 665. Citing Commonwealth versus Hayes, 311, Massachusetts 21, 24, 25, 40, Northeastern 2nd, 27, 1942. See Commonwealth versus Hobbs, 385, Massachusetts 863, 869 to 870, 434, Northeastern 3rd, 633, 1989. The jury are not required to conclude unanimously that the defendant was either the principal or the joint venturer, so long as sufficient evidence exists to support either role. Commonwealth versus Ellis, 432, Massachusetts 746, 761, 739, Northeastern 2nd, 1107, 2000. Here, the evidence would support a guilty verdict on a theory of individual liability, the compact discs, as well as on a theory of joint venture, the remote. The judge's instructions to the jury were proper. Judgments affirmed. Was it too fast?
No, it was okay.